So I was supposed to go live with a couple people tonight, but they bailed out last minute here. So I have some questions that I want to get answered. So I was going to get them done. These questions, I break them up into smaller videos. So this is just to respond to some questions that have come in. So thank you for joining me. All right. So there's people out there that are portraying themselves as me. They've opened up accounts and they keep on asking people for money. People keep giving them money, and unfortunately, that's detracting from what we got, you guys, and that's a problem. So there's nothing we can do about it. I mean, I've contacted TikTok, and they said that there's nothing wrong with the account, even though they're using my logo, pretending to be me, sending out messages. They won't do anything about it. So I don't know, but I keep getting messages from people saying that they donated, that this person said that they were going to come to their city and help them in a court case and ask for a couple $100, and they gave them. So guys, don't donate to a random person that sends a message to you. Especially read their messages, because the messages I'm seeing, that person does not speak like me, and I don't put in those little the little acronyms of things in my text. I write out regular plain English. So I don't know, but this has had a major impact on donations this last couple of weeks, because as they've been going to someone that doesn't have anything to do with this. So that person, we know who they are. I know who it is, and they're just mad that I asked them not to be part of this. So, but again, there's nothing we can do about it. TikTok won't shut it down, and Cash App won't do anything about it either. So if you guys get messages from someone asking you to send them money, don't send them money, please. Please don't send them money. All right, so first question here is, are there any exclusions to these affidavits, such as drug charges? So no, the answer is no. There's no exclusions. You see, what I'm doing, this has nothing to do with the charge. It has nothing to do with the offense. It has to do with with the crimes that were committed by government against the people. Again, I'm not claiming anyone's innocence. I'm not fighting for any one of these guys' innocence. I'm fighting for their guilt, because guilt is a process, and you got to follow that process. And if you don't follow that process, there can't be guilt. Even Scripture says that where there's unlawfulness, there can't be guilt. So, where government is acting outside of the law, there can't be guilt, because what they're doing is unlawful, and therefore everything they produce is going to be unlawful. This is about getting our government to return to the actual law, right? About getting them to accept the fact that you guys are criminals, and if our leaders are criminals, then they're going to lead us toward criminality. If we want to have a good society, we need to start with good leaders. They're going to lead us in a good direction. And if they don't want to do that, then nobody can be guilty. Right? Because by the leadership's guilt, there can't be guilt. It's a very, very simple concept. This has nothing to do with the prisoners. This has to do with the leadership and what they've done to those prisoners. Because there isn't a single prisoner here in America that is in prison on a legal and lawful constitutional judgment. There isn't. And I didn't want to make those statements early on, because that's a little bit insane to think, but it's true, and it's coming to be understood by a lot of people now. Our laws are written and they're recorded, just as Chief Justice Marshall said, and I love his statement from Cohen versus Virginia. But the power of government is defined and limited, and those limits can never be mistaken or forgotten, because the Constitution is written. To what purpose are powers limited, and to what reason are those limits committed to writing, if these limits may at any time be passed by those intended to be restrained? The difference between a government with limited powers and unlimited powers is abolished if these limits do not confine the person on whom they are imposed, and if acts prohibited and acts allowed are equal obligation. Why do we write the law? Why do we have the Constitution? I mean, if the Constitution is at discretion, that doesn't sound like a very good Constitution, right? I mean, if the Constitution is suspended by the governors, that doesn't sound like a very good Constitution either. So the purpose of a Constitution, not just ours, but any Constitution, the purpose of the Constitution is to establish rights and limit powers. People have rights, government has powers. So the rights are preserved through a series of limits on the government, through the obligations that they have. So, the Constitution, the main body, Articles 1 through 7, those are all the obligations of government. Okay? So when it says the trial of all crimes, with the exception of impeachment, shall be by jury, that means that all crimes except for impeachment must be by jury. See? And that's an obligation. So if government has the obligation to ensure that all crimes except for impeachment are adjudicated by a jury, then why are they able to disregard that and have people enter into a plea, right? Or adjudicate in, as bench trial? That's not a jury trial. That's still the judge who's absolutely partial and biased, make the decision. So, government has the obligations. And another question here was the courts say that a failure to invoke a right is a waiver of it. And this kind of goes to that, is that it's not. Your failure to invoke a right has nothing to do with their obligation. Okay, their obligation exists before you walked in that courtroom. Their obligation exists before you have an opportunity to give up that right, because government's obligation exists before the rights can be violated. See, rights always derive from another's duty to act. Okay, that's you guys got to understand that. Rights always derive from another's duty to act. Where there is no duty, there cannot be right. Okay? Now, there are duties that exist that do not have a corresponding right, such as duty to God, duty to spouse, duty to country. But there are no rights that exist without a corresponding duty. So let me break that down. Okay? Rights exist. They always do. You have the right to life. You have the right to your property. You have those rights. Those exist. But to protect those rights, we need an enforcement statute. We need an enforcement element. That's where the law comes into play. So you have the right to have your property, but we want to preserve that, right? And so what we do is we create a law. Here's a law, right? And that law creates an obligation, okay? An obligation is created by every law. Now, the obligation can be seen from two different perspectives. From the one bound, the obligation is a duty. From the one entitled, the obligation is a right. So the obligation creates the right, the protection, preservation of it, as well as an obligation. So for instance, I have an obligation to not kill someone. I have an obligation not to steal from someone. I have an obligation not to assault someone. If I breach my obligation and I assault you, then your right to be assaulted has been violated. But it's not violated until someone breaks the law, breaches their duty. So the same applies to any law. It doesn't matter whether that law is a statutory law that deals with person to person, or if it's a constitutional law. If the law creates the obligation, then the obligation cannot be waived, because before you can give up a right, you have to breach the obligation. The obligation comes before the right, guys. You have to understand this concept before you start fighting for civil rights. If you don't understand this, then you'll never be able to get past what they're trying to do. You can never waive a right, because your rights derive from their duty to act. So if a judge says to you, do you want to give up your right to a trial by jury? Before you have that right to give up, that judge has to breach their duty of ensuring that right is provided. Therefore, you can't waive them. They're inalienable. You have them forever. They have a duty to provide them to you. Therefore, you don't have a right to give them up, because your right derives from their obligation. Okay? If a judge asks you, do you want to give up your right to trial by jury? In order for them to do that, they would have to break the law by not providing the obligation. Okay, so this is upheld in a number of places too. First off, it's upheld. Let's go to Miranda versus Arizona, the United States Supreme Court. Where rights secured by the Constitution are involved, there can be no rule or legislation created which would abrogate it. So where rights secured by the Constitution are involved, there can be no rule, which would be a judge-made ruling, right, a rule, or legislation, state statute, or even a Constitution, United States Congress statute. There can be no rule or legislation created which would abrogate it, which means reduce, diminish, take away. So when it comes to constitutional rights, there's no way that you can have a ruling that would take it away, or legislation that would take it away, or abridge it. Okay, so there's the first one. The second one is found in the rules of civil procedure, where it says that rules, and rules again come from judges. Judges make rules. So rules must not conflict with statutes, nor impair the legal rights of the parties involved. Thus, a court has no power to create a rule which would constitute a waiver of a constitutional right. Again, rules must not conflict with statute, nor impair the legal rights of parties involved. Thus, a court has no power to create a rule which would constitute a waiver of a constitutional right. Constitutional rights can't be waived. They can't be, you know. And the judicial branch has no authority to create a rule which would amend the Constitution or grant their agents the right to be able to accept a waiver, because that would be the judicial branch, again, amending the Constitution other than lawful manner. See, all this has to do with who changed the Constitution, who is responsible, who's in the driver's seat here. The people are. So all of this shit that we're dealing with, all this shit, this is all based upon judges saying that they can do it, or states saying, oh, well, we can do it, or whatever. I mean, but regardless, those are entities that have no authority to amend the Constitution of the United States. No amendment, no authority whatsoever. All right. Yeah, they do cite case law, but I'm telling you guys the truth, because the Constitution, if you understand it, you can use that as a mechanism to enforce your rights. But you guys, you have to understand it, because if you do not stand for your rights, then yeah, they're gonna lead you astray. But at the end of the day, no, you cannot waive rights. Now let me explain to you the reason why. Okay, and it's simple. But I'm only telling you guys this not because this is what they do. I'm telling you guys this so that you guys can understand why. Why? So the reason why the duty comes before the right is because the main body of the Constitution, Articles 1 through 7, those are the obligations of government, right? The obligations of government. So Article 1 is the legislative branch, all the things they have to do. Article 2 is the executive branch, all the things they have to do. Article 3 is the judicial branch, all the things they have to do, okay? So the Articles 1 through 7, those are the obligations of government. Nowhere within Articles 1 through 7 do you find a right. Nowhere. You find in Article 4 the illusion of rights, right? But it doesn't say what they are. It says in Article 4, it says that citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. So, you know, it says that there are privileges and immunities of the United, but it doesn't say what they are. To understand what those are, you'd have to go to a case called Corrywell versus Washington, United States Supreme Court. This is George Washington's grandson, and you would learn that will tell you what those rights are. But nowhere in Articles 1 through 7 do you find a right, because those are all duties. Now, the main body of the Constitution that was ratified and adopted by the people on September 17th, 1787. Okay, 1787 was when we adopted the Constitution, when we adopted the rights or the duties, right? So government received the duties in 1787, but then the Bill of Rights were adopted and ratified by the people on December 15th, 1791. Therefore, the duty came before the right. Okay, duty before the right. We ratified the Constitution, we ratified the duties of government, they accepted it, and then a couple of years later, then we ratified the rights, therefore the duty comes before the right, okay? Duty always comes before the right. Now, there are some state constitutions that I'm worried about, because there are some state constitutions that place the rights before the duty. So like Article 1 is the rights of the people within the state constitution. And then like Article 2 or Article 3 is the duties of government. That's wrong. But nonetheless, the state constitutions have all put themselves in subjection to the United States Constitution, and therefore, the state constitutions, they don't matter, if they're in conflict with the Constitution of the United States. So with regard to the things that we're dealing with, the state constitutions don't matter. But I have noticed that there are some state constitutions that do have the rights before the duties, and they're not supposed to be that way. The rights always come after the duties, and they should have them all in that format within their constitutions. But nonetheless, the United States Constitution, the duty came before the right. Therefore, rights always derive from another's duty to act. So you can't give up right because they're an obligation that's imposed upon someone else. If someone were to say to you, you want to give it up, they would have to break the law for you to give it up, because the duty came before the right. So to answer that question, failure to invoke the right is a waiver of it? No, not at all. Because government has the duty to do it. That's why Article 6 says the judges in every state shall be bound thereby, anything in the Constitution or laws of the states contrary notwithstanding. The judges are bound to do it. The state judges are. And so that's why I say that the people of the United States, we have the right to due process of the law because the judges in every state have the duty to ensure that those rights are provided. The judges are there to ensure that the rights are provided. Therefore, when the judge says, oh, do you want to give it up? They have to break the law to do that. They have to break the Constitution. You can't give up a right to an animal. They were given to you no matter what. They cannot be given up. Now, they also use threats quite often to try to give you have you give them up, you know. And one thing that's important to remember is that there's a maximum law that says that you cannot be punished for having a right. Okay? You can't be punished for having a right because they're your rights. So, but in a case of a plea bargain, for instance, when the prosecutor comes up to you and says, well, if you don't plead guilty, I'm going to send you to prison for 20 years, right? Well, is this person, so they have the obligation to try you by a jury trial. And so when they say to you, well, hey, if you come and make us have to, do our job and actually have a jury trial, we're going to punish you more than if you plead guilty. We'll let you go right now. You're out the door. You're being punished for having a right. They're punishing you for having to fulfill their obligation. And they can't do that. I mean, you can't be punished for having a right. And yet all these plea bargains are all resulting in, a lower sentence because, well, you agreed to not come and testify. You agreed to not make them have to do their job. So, when we go back to the duress issue and we talk about duress and the weapons that they're using to force people into doing what they want them to do, these prosecutors they've got the tactics down. And that's why the case that we have, we're bringing up the formula of intimidation. Now, you see, robbery and extortion are extremely close together on the criminal spectrum. Robbery is to formulate a contract through illegal means with the threat of immediate bodily harm. Extortion is to formulate a contract through illegal means with the threat of future bodily harm. So let's take the robbery now. So I have certain powers. I have the power to go out and buy a gun. If I go and buy a gun and then I come up to you and I abuse my powers and I say, if you don't give me your money, I will shoot you, right? What's happening is we are formulating a contract for your money. You're giving me your money under a contract. But the way in which we formulate this contract is through the use of immediate bodily harm, which means that is the crime of robbery. To formulate a contract through illegal means with the threat of immediate bodily harm. Now, that's a crime, right? You'll go to prison for that. You cannot formulate a contract through the use of duress. Now, if I'm a prosecutor, I have certain power as well. I have power to send you to prison and power to give you charges. If I come up to you and I say, if you don't plead guilty, I will send you to prison for 20 years. What we're doing is we're formulating a contract, right? But the way in which we formulate this contract is through the use of duress, through the abuse of my power by threatening a future bodily harm, right? That's extortion, right? Formulating a contract through illegal means with the threat of future harm. So you cannot ever formulate a contract through the use of duress. In contract law, a contract is void if the way in which the contract is formed is illegal, then the contract formed is then illegal. And duress is as a justifiable defense for a crime, a breach of contract, or tort. So when you use duress to formulate a contract, that contract's void, wholly without force effect. I can't hold a gun to your head and say, sign this contract, and then hold you accountable to the terms of that contract. Neither can a prosecutor. So duress is a justifiable defense for crime, breach of contract, or tort. So understanding those two scenarios, the robber versus the extortion, the prosecutor. The case is bringing up what we call the formula of intimidation. And all intimidation follows this formula, all of them. It goes like this. If you don't do X, I will do to you Y, whereby X is my envisioned outcome and Y is the result my powers can cause. So again, the robber will employ the formula here. If you don't plead guilty, I will send you to prison, right? My envisioned outcome, X, is I want you to plead guilty. If you don't give me your money, I will shoot you. My envisioned outcome is I want your money. Result my powers and cause, I will shoot you. We now formulate this contract, but the way in which we formulate it is through the use of intimidation. Therefore, that is meeting the formula of intimidation. Now, with the prosecutor, if I employ the formula of intimidation and it follows the same format. If you don't plead guilty, I will send you to prison for 20 years. My envisioned outcome, X, is I want you to plead guilty. Result, my powers, cause is I will send you to prison for 20 years. So we're now forming a contract to the abuse of my power by threatening future harm, right? And so that is extortion. Now, what's even more interesting is that when you deal with the law of extortion, right, when you go up and you read it, it says that there's certain acts that would constitute intimidation under that particular law. And it specifically states that any threat of criminal sanction would constitute the intimidation that would be necessary to meet that particular law, to meet that particular standard. So if you threaten future criminal sanctions, then you have committed the crime of extortion according to the law. And these prosecutors are all threatening criminal sanction. So, you know, when you consider the mob, right? I mean, the mob, all they wanted was they just wanted you to give them money, right? To do what they want, yeah. And so they'd come in and they'd threaten you in the same way. I'll just send you to prison. I mean, these guys are nothing but just a bunch of gangsters. They're organized crime, engaged in ongoing organized criminal activity, and they need to be shut down, especially if they're not willing to step up and act lawfully. They have no right whatsoever to be out there saying that they're, you know, honorable, stand up when I walk in the courtroom, or we're out here, you know, protecting the citizenry. No, you're not. No, you're not. So, you know, we have a major RICO going on. We all know that. And because of corporations, then they fall right under RICO, all these states. And when you're dealing with RICO, that's the only federal offense that anyone could prosecute. So I could prosecute a RICO offense. And we kind of set it up for that because, you know, we've gone to the corporations, we've notified them of these crimes, we've shown that they're all in a criminal conspiracy, in ongoing criminal activity. You know, 3 or more times over 6 months, absolutely. You know, I mean, they're doing it 3 or 4 times every minute, every day. So we've got the whole entire enterprise, and not only just the state enterprise, but the federal one as well, all tied up into ongoing criminal activity every single day, and we've given them opportunity to step up and change that behavior, and they haven't. You know, so there's no denying that they're all, you know, complicit in it because of their negligence, because of their unwillingness to address the criminality of the people. And that's why, you know, I mean, this would work normally if we were dealing with honorable people, but clearly we're not dealing with honorable people. So, you know, I mean, it takes a little while to realize that because I came from there. And I thought that we were going to find some honorable people, but we haven't. So if that's true, then, you know, then none of those people should be in a position, because not only can they not be, because, you know, they're committing the crime of perjury, a violation of public trust, but, you know, but they're robbing the people. And then they walk around and portray themselves as the good guys. You know, there's a couple things on this new administration that came up, right, that I'm worried about. One is that there was there was an order from the past president. I'm not a fan of him, but nonetheless, there was a past order to shut down the private prisons on the federal front. So there was an order that they were going to start shutting down all these privately held prisons, Geo Group, Core Civic, CCNA, you know, these companies that are out operating prisons here in America, that are traded on New York Stock Exchange. They're for-profit businesses. See, when we saw Geo Group and CCNA come up, you know, a lot of people thought, oh, well, you know, it's a private business, and so it'll streamline operations and will actually save money, and it doesn't save money at all. It actually costs every bit as much. And then there's also, you know, a whole bunch of other issues like, you know, minimum bed rates and things like that within the contracts that provide additional liability. But nonetheless, there was no cost savings when it came to private prisons. But some of the things we saw was that they're undermanned with their staff. And so there's a lot more violence within these prisons. There's a lot less people that are getting out. There's a much higher rate of sanctions and violations being handed out. And then they removed all education from these particular institutions. Because once again, if you're a slave, the last thing you want to do is educate your slave, right? You don't want to educate them. So we saw the education programs all being removed at the moment that the private prisons came into play. But so there was an executive order that was signed saying we're gonna shut them down. And remember, we also had a moratorium on death penalty in the federal side as well. There was no people being executed on the federal side. But here this last week, we saw the new president sign in 2 executive orders that reverse both of those, right? So now we've got a green light to go ahead and start executing again on the federal side, which is not good at all. And then we also have the private prisons that are not going to be shut down. They're going to continue to operate. Those are 2 things that have me pretty concerned, because that's going the wrong direction for what we're doing, right? Because if the administration had really heard or had really taken me seriously after presenting this to them a couple times, I don't think they'd be heading that direction. So I don't know what they're doing, but if we're talking about continuing to operate private prisons, then we're going in the wrong direction. And if we're talking about executing people now on the federal, we're going in the wrong direction, because we could show that they're all not innocent, but we can show that they're not guilty, because guilt's the process and they didn't do it. So I don't know. But when it comes to the death penalty, I think that we need to get these things resolved before we should be executing anybody else. Because when the system itself says that in the criminal procedure manual, the 4th paragraph of the preface, it says most prosecutors across the United States agree that as much as 15% of people in prison are innocent, but that's an acceptable deviance because our system isn't perfect. So they say that 15% of people in prison are innocent, but that's okay because our system isn't perfect and it's luck of the draw, right? Well, again, I would challenge them to take a look at what they're doing, because the one thing that exists for the protection of the innocent from hasty or malicious charges, you guys removed in 1887, and you haven't had in place since then. That's the purpose of the grand jury. Absent that, there is no protection for the innocent. So you can't expect that innocents will be suffering because you're acting arbitrarily based upon an officer of the state's allegations, and you're not listening to both sides of the story. You're hindering and obstructing the free speech so that you can control the narrative, and that's a miscarriage of justice. That's a skewing of the disposition of a legal proceeding so that you can win the case. So the problem is that when we look at the death penalty, right, the system says, yep, 15% of people in prison are innocent, but that's okay. Well, no, it's not okay, because we have a system that was designed to ensure that innocence doesn't suffer in America, and now we're just going to say it's okay to have, roughly 600,000 people across America innocent suffering right now today, because that's the number that we'd be looking at with 10 million people in the system pre- and post-conviction. 600,000 people currently innocent suffering. Most of them are pre-conviction, because a lot of people go to jail and then they sit in jail for months before they are let out without charges. They just sit there. But if the system says 15% of people in prison are innocent, well, so we've had roughly 1,500 people executed here in America since the late 70s when we put the moratorium in. 1,500 people. And of those 1,500 people, 139 of them have been proven to have been innocent after they were executed, after they were murdered. That's not a good number. That's about 7%. Of the remaining, another 186 were exonerated after being placed on death row, meaning they were factually innocent and released. Those 2 numbers alone, that's 18%. 18% of the people on death row were factually innocent. And that's proven. And those are just the ones we know about, because we still have evidence. Most of the time when you deal with a death penalty case, they destroy the evidence right away. As soon as the trial's over, they just get rid of it, and so there's nothing there. And so, dealing with one of these people and exonerating them, or even after they're dead, clearing their name, is really difficult because the evidence is not available. They destroy it. Which is one of the things that I'm looking at when it comes to the RICO case, is Sarbanes-Oxley, because that deals with the destruction of evidence that has to do with counting systems. And again, remember, this is nothing more than an accounting system, right? It's a debt that's owed to society, right? And we're reconciling the debt. It's all about accounting. And so, and accounting's banking and all the rest, but this is all about accounting systems. And so when you cover up or when you destroy evidence to cover up, crimes within accounting, that falls under Sarbanes-Oxley. And now we have some other cheat to be able to throw at these people under the RICO statute. But I particularly like the misappropriation of retirement fund, retirement accounts, because that's one of the elements of RICO. Because the United States is just nothing more than a corporation. We know that. The employees are the people of the United States, right? So as the people of the United States, as the employees of the corporation, then we created a retirement account, right? And we put money into that retirement account. And so the law says that if you were to take and use employees' retirement account for any purpose other than their direct benefit, then that would be a violation of RICO. And that's what they've done. I mean, they've taken all of our money from the Social Security and they funneled it to Ukraine. They paid off states for stealing children. They've done a whole bunch of different things that's directly outside of our retirement benefit. And now there is no retirement funds available. So we would have legislation, the United States Congress, on that particular element of RICO. And it took me a little while to figure out how we were going to get the legislature in. I mean, we've obviously got, the judicial branch and the executive branch tied together, but we don't have the legislature. But I think we can get them very easily on the misappropriation retirement account, because there is no money left. There is no Social Security. I mean, we're going to be lucky to get any. And so they've taken all that money, they've funneled it elsewhere, and as a result, they've misappropriated that money. All right, so okay, so back to the exclusions. Are there any exclusions? Answer no. There's no exclusions to this. We're not fighting for someone's innocence. We're fighting against their guilt. And so we're not going to the end. We're not dealing with the judgment. We're dealing with the beginning and saying, did the state have authority to be able to arrest you? Did they have authority to be able to bring charges against you? The answer is no. And as a result, no, there's nothing excluded. We're fighting for everyone. Every single slave needs to be raised up to equal status. That's the only way that we're going to remove the slavery institution. Is we've got to remove every single slave and the slave status, bring them up to an equal status, and then we can move forward as a nation where the government and the laws have to treat everyone equally. You see, when our country started, and our founders and forefathers, when they failed to release what they called their property and make all men equal, then when they started a government where all laws apply equally, but they had a classification built into it, they didn't create a justice system because it's not built on just principles of all men being equal. They built a criminal enslavement system because slavery is and has always been the foundation. Slavery is the foundation because there were classifications of people. So we have a system that has the ability to perpetually discriminate built into it. And that's why we always see, the laws applying unequally here in America because they can. Because our founders did not do what they needed to do. They didn't start an egalitarian form of government. What they did was they started a system that has the ability to discriminate. And the system will always find some way to discriminate until we fix this, right? Bring everybody up to an equal status the way it should have been 243 years ago. All people equal, all men, women, everyone is equal. And then we can start over the country. That's the only way we're going to remove this slavery industry, business from within. Now, again, I'm not saying we have to release any dangerous people. But what I am saying is that if their conviction is unconstitutional, that has to be addressed. It has to be addressed. We can't keep anyone's conviction in place because that guilt is not valid. Government cannot justify their unlawful acts, their crimes, to keep any convictions in place. If the convictions are unconstitutional, if they're illegal, they got to be removed. But that doesn't mean that we have to let those people go, right? It means that we have to switch them from a criminal incapacitation into a civil incapacitation. And when we do that, then we're going to be treating them. Then it's a hospital based. Then it's a treatment based as opposed to punishment. So one of the first things we got to do is we got to remove this from the Attorney General's responsibility and switch it over into the Health and Human Services. This needs to be a matter of public health and not a matter of punishment. I need more water. All right, so there are no exclusions. Everybody's included. We want everybody included in this. If you have been charged with or convicted of a crime by the United States justice system or system subject to the jurisdiction thereof, you can be a part of this. Now, what does a part of it mean? It means that you have been a victim to a crime by government, by an agent of government, whether it's state government or federal government, it doesn't matter. If you've been charged with or convicted of a crime by the United States justice system or system subjected to the jurisdiction thereof, you're a victim. You're a victim, period. Which means that what government did to you the moment that they arrested you is all unconstitutional. Everything after that is unconstitutional. You see, the government that was created for the sole purpose of preserving our liberty can't breach that obligation of preserving our liberty in order to enter into a new contract with people to enslave them, right, and take away their freedom. Government was here to protect our freedom, not take it away. So when that government does take away our freedom unlawfully, then we have the right to be able to restore the original liberty, go back to where we were, and then seek injunctive relief as necessary. To be made whole once again. The injunctive relief is not what I'm doing. I'm starting out at the beginning. I'm dealing with the judgments, voiding them through the criminal acts, because again, you guys, I deal with substantive law. I don't deal with adjective law. I don't do the courtroom shit. You guys will be able to do that with attorneys sometime later on. We're going to deal with the first part here, which is, did they have the authority to be able to prosecute you? Absolutely not. They didn't. Okay? And for lots of different reasons. We've been through them. Jurisdiction, right? Article 3, original jurisdiction. Absence of the indictment by grand jury, threats, intimidation, coercion, duress, detainment or pre-investigation detainment. I mean, all of these things are all things that would eliminate their ability to be able to do this. You're not supposed to be sitting in jail, while they investigate. You're not supposed to be sitting in jail before due process is taken away. You're not supposed to be sitting in jail without an indictment by a grand jury. You're not supposed to be sitting in jail without seeing a hearing and having an opportunity to confront the hearsay evidence that's against you. And you're not supposed to be sitting in jail when the state itself is a party in the cause. So if you've been charged with or convicted of a crime, you can submit an affidavit. And what we're doing is we're bringing those affidavits together to litigate this in one single swoop. This has been litigated once before, 1793, Chisholm versus Georgia. We're going to successfully do it again. So Chisholm won, and we're going to win once again. And all we're doing is just reminding them, that the Constitution is our weapon, and that's our sword, and it protects us. It doesn't protect them. So when the slave owners, take that Constitution and then they put into place their rulings that amend it and modify it so that they can, advance their industry, then we're going to take all that shit away, because that's not how that works. Constitution can only be changed by an authentic act of the people, not by the judicial branch, right? Not by executive branch, but by the people. That's what the American people believe in. That's what our faith is in, and that's what everyone else judges know. But we've come to where we're at today because the United States Supreme Court believes differently. That they believe that they can amend the Constitution of the United States, and that's what we're challenging. That's what we're dealing with. Supreme Court does not have authority to be able to amend the Constitution of the United States, placing their rulings into the foundation by removing the provisions of the Constitution and then directing all the states to follow their rulings. Because once again, just like I said in the rules of civil procedure, rules must not conflict with statutes, nor impair the legal rights of the parties involved, right? So rules cannot impair the constitutional rights of the parties involved, because the judges are tethered to positive law. They have to follow the positive law. And if they don't, then they're legislating from the bench, they're creating law, they're amending law, and they have no lawful authority to do it. So all these people, they need to have their convictions removed, the judgments removed. And I don't know what that's going to look like, you guys. I don't know, because all I'm doing is bringing forward a problem, right? And trying to get a solution. but the people are going to have to make that decision. I mean, are we going to release him? I don't know. Are we going to restore all their liberties? I don't know. But I do know what should happen. If the Constitution of the United States is the supreme law of the land, right? If that's what it is, and if it can do the things that it says it can do, if its words are supreme, then I do know what the outcome is supposed to be. All these people have to go free. Have to. There's no choice on that. If the Constitution is what it says it is, if we follow it. So the people are just going to have to decide that, is that what we want? And, if it is, then we know the outcome. But what you guys are hearing right now, and what you're going to continue to hear, is that they're going to be pointing at the end. They're going to be saying, "Oh no, we can't do this. We're going to let all these bad people go, or and it's just going to be chaos and mayhem and all this other shit." And that's not true, you guys. It's not true. That's what they want us to look at. They want us to look at the end and say, okay, if I win, then all this bad stuff's going to happen because we're going to let all these bad people go. They want you to look at that. They're going to continue to use fear in order to keep you guys from understanding, what's the right thing to do. See, when you have an issue, you either can do the right thing or the wrong thing. There's only two choices. You can't do anything. I mean, you can choose to do nothing, but that's still the wrong decision. Because if you should do something, you don't do it, then you're sinning. So you can either do it and make the right decision, or do nothing, or choose to do wrong. Those are the only choices you have. There's no in between. Law is black and white. So, if the law says that no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury, that's clear. You got to have it. And that would mean that in no instance can you not have it. But when judges, start creeping in their bullshit rulings and start saying, "Oh yeah, but we don't have to have it on Thursday night between fucking 9 o'clock and noon or midnight, right?" Or whatever. What they're doing is they're creeping in and they're encroaching on it, and they're making instances in which they can make it go away. And they've chipped away at this for years, right? I mean, but it's all these laws. I mean, it's the right to travel, it's the right to own your property, it's the right to be secure in your person's property, papers, the right to have your children, a relationship with them, all these rights, the right to earn money and not be taxed. All of these are limitations that they had based upon the law that was in place. Obligations that they had to follow, that they slowly started abridging bit by bit. And people say to me, they're like, yeah, but we need to have officers that can make arrests for these offenses, and be able to arrest without an indictment and take them into jail for a certain amount of time until we can schedule one, a grand jury. And I'm like, no, you can't, because that's not what the fucking law says, right? So if you're gonna make concessions to the law, then what's the fucking point in having the law? The law is what it is. It is what Duralex said lex. It might be hard, but it's the law. So we can't make concessions to it, because when you make concessions to it, then you're permitting them to break it. And we can't permit them to do that, especially with civil rights, especially with the Constitution. It's black and white. Everyone has it or no one has it. Because any right that can be removed from one can be removed from all, and it's no longer a right, but an illusion of right. So it can't be taken away. So that's why I take the hard-nosed approach on it. That's why these judges and politicians, that's why they don't like me. Is because they think that this is much more destructive. But what they're trying to do is they're trying to make you look at the end, and they're saying if we do this, look at the bad that's going to come from that. But we got to look at the issue, right? The issue. That's why I'm bringing up the issue, right? We have a problem here, right? We're certainly in the wrong place, right? We're going in the wrong direction. I don't think there's any denying that an 800% increase in the prison population in 30 years is definitely going the wrong direction, right? And 16 times more prisoners than the next closest industrialized nation. That certainly is going the wrong direction, I would think. So we gotta look and say, okay, why are we going the wrong direction? Well, let's look at the issue. Did we make the right decision when it came to the adjudication? How to put a person in prison? Because maybe we've got a massive increase because we're not following the rules. And that's precisely it. So again, right will always produce right, wrong will always produce wrong. We're in the wrong place right now because in 1887, the Supreme Court made the wrong decision and said we're not going to follow the law. And by making the wrong decision, it set us on a path in the wrong direction. leading to mass incarceration and all this other stuff. Because the system itself is able to act arbitrarily and capriciously to lock people up. People that they say is, that 15% of them are innocent and being executed. So we made the wrong decision. The Supreme Court did. Now the court's going to make you look, and they're going to say, okay, look at the end. We can't do this because all these bad people are going to get out. And the answer is no, Supreme Court, you can't do that. You can't justify your crimes that you committed, in 1887 in order to justify where you're at, in order to, not have to address this situation that you're in. It doesn't matter how big this is. It doesn't matter how many times they've done it or how long they've done it. Wrong will always be wrong. And what they're doing is wrong. So if they come and they say, well, yeah, but we can't do this because it's so big. Well, I don't fucking care how big it is. Because remember, the people created the Constitution. We expected them to follow those rules. We follow those rules, but they didn't. And so as a result, the people didn't do this. It's not their fault. And yet they're suffering for it because of the government's incompetence. So we can't permit government to tell us that this is too big of a deal. We can't do that. We can't do that. So we need to continue to push and say, no, you're going to have to fix this, government, because you did this, you caused this is your fault. And you can't continue to hurt the people because of your incompetence. The one thing that protects the innocent from any malicious charges was removed. The grand jury, you remove that, and innocents will absolutely be suffering in prison every single day, as they say that they are. That's where a person is innocent until proven guilty. So if you are supposed to be innocent and treated as though you're innocent until you're guilty, then you must be coming in to present that hearsay, to confront the hearsay evidence that's against you in a fair and neutral proceeding before you've been arrested, before you've been held for an infamous crime. You've got to be treated as though you're innocent. So if you're being arrested before you've had the opportunity to confront the hearsay evidence against you, then you're guilty until proven innocent. And that's the shift in the burden of proof. It goes back to the use of information. So when you look at the use of information, information is an affidavit. And that affidavit is, at common law, considered truth. It's presented as though it's truth because the officer is saying that, this information is factual, truthful, and correct, submitted to the judge, and then the judge makes a decision to perform the arrest based upon the affidavit. But the problem is that affidavit is your accuser. And your right to confront your accuser evaporates the moment that they use an affidavit to do it, because you can't put that affidavit on stand and cross-examine it. So when they present the affidavit as your mechanism to charge you for the crime, they've set up what's called an irrebuttable presumption of guilt. It's an irrebuttable presumption of guilt because you have never had the opportunity to rebut that accusation, and any unrebutted accusation is truth. So when they present this affidavit as truth to the judge, then the judge accepts it as truth. It says, okay, well, this guy is under arrest because he did this. And now you're arrested and you're put into jail and you're deprived of certain rights that you would be entitled to otherwise, like your right to go out and earn money and have a family and use your property and so on. You're being deprived of all those without even an opportunity to confront those accusations. You've never even had the chance to tell your side of the story. So they hold you in jail. Threatening and abusive environment, with duress and coercion. And they're doing that to try and make you more malleable. But what happens then is that with an irrebuttable presumption of guilt, again, you are presumed guilty until proven innocent. You're presumed guilty based upon the mere fact that you're charged with a crime. And it requires you then to go out and collect evidence in order to prove you're innocent. Now, that's a shift in the burden of proof. Normally, the prosecutor would be responsible for proving that you're guilty. The state is responsible for proving that you're guilty beyond a reasonable doubt, but not in the case of an irrebuttable presumption of guilt. In the case of an irrebuttable presumption of guilt, the burden of proof shifts from the prosecutor on the defense, and the defendant then has to go out and collect evidence to prove that they're innocent. And so this is a shift. But Blackstone says that this particular thing occurs when there's a breakdown of due process, and the system focuses on speed and efficiency as opposed to established procedures and processes. Blackstone says that this is absolutely a breakdown of due process. And so we can see that when you're being treated as though you're guilty until proven innocent, when you're being arrested, when you're not coming in off the streets innocent, and the judge is treating you neutrally as one person accusing of a crime, another person confronting those accusations against them. So when you're denied the right to be present in the grand jury, that again is a crime. It's an abusive process. It's not the intended purpose of that grand jury, because you're denying the accused the right to the benefit of the very proceeding that exists for his protection. When you don't conduct the grand jury and you just perform the arrest, now you're presuming guilt until proven innocent. You're presuming they're guilty based upon the mere fact of charge, right? So all of those are unconstitutional. They're contrary to the way that we were supposed to do it. And so we have a shift where it was supposed to be innocent until proven guilty, and now it's guilty until proven innocent. Where you were supposed to be treated as though you're innocent coming in, and now you're treated as though you're guilty until you can prove that you're innocent. And we're always under the belief that the prosecutor had to prove that you're guilty beyond a reasonable doubt, and now you have to go out and collect evidence to prove that you're innocent to overcome their preponderance of evidence. All of which are a complete shift in the hierarchy or the structure of our law. Okay, so someone said the other day that I sold out. That they heard a rumor that I sold out, and that I agreed to not file paperwork or whatever. Guys, I'm going to humor that for a moment here, and I'm just going to say that I didn't give up everything for nothing for money. Like, I used to have plenty of money. I used to make $870,000 a year before I did this, and now I make nothing. But that was a choice that I made. So anybody that says that they would believe that, you got to look at the situation here, because one, they'll say that I did this because of money. This has nothing to do with money, guys. I mean, I'm not going to get shit out of this, right? The government's not going to pay me for the time that we've done, and I'm not even asking for the money. This isn't about money. If I wanted money, I could have had it. If I wanted money, I could have already settled. But I didn't make this about me. I made this about the country. I made this about trying to figure out how I can get all of you the rights that you're entitled to. It doesn't do me any good to go to Arkansas and serve Arkansas. It doesn't do me any good to go to Virginia and serve Virginia. It doesn't do me any good to do those things. It does other people good. So I want to get out here, and I want to help the country. That's the reason why I'm doing it. You guys got to look at words and actions. You guys just don't look at the words, right? If the words are contrary to my actions, then I don't know why anyone would believe that. I mean, I'm not selling out. So, I didn't give up my wife and my kids and my house and my career and my honor and all that. I didn't do that for anything short of you guys getting your fucking rights. So you don't have to worry about me selling out, because it's not going to happen. There's only two ways that I get out of this. God calls me home, or that army retreats. There's no other way. Someone asked me if I've seen the 17 fringe flags removed from around Washington. You guys know why there's fringes around those flags? Admiralty jurisdiction. Well, I haven't seen them removed. I haven't been back in Washington since the inauguration. I'm kind of reluctant to go back there because I'm a little bit concerned about some stuff that's going on, But I haven't been back to DC yet. So no, I haven't seen the fringe flags. But we do need to remove them. But the only way we remove them is through finalizing bankruptcy. So if we are finalizing bankruptcy, then that would be great. That's awesome. But in order to finalize the bankruptcy, we have to discharge the debt. And I don't think that's going to happen under a silo. That's not going to happen without us knowing about it, because that's $38 trillion worth of debt. But part of the national debt also is the debt that's owed to society. It's these prisoners. These go hand in hand with one another. That's why the book of Leviticus, when it talks about the Jubilee, it says all slaves must be released and all debt must be forgiven, because those two things come hand in hand. Because the slaves are a slave because they have a debt that they owe, right? So if we're going to remove all of the flags, these 17 fringe flags, and we're going to get out of Admiralty jurisdiction, the only way we can do it is by discharging the debt, which is exactly what I'm saying we have to do. Let all prisoners go. Raise all the slaves up, discharge, release the slaves, and discharge the debt. So I haven't seen 17 flags removed, but I'm going to venture to say that either the ones that removed them, if they were removed, they don't understand why they were there. They don't understand the true purpose of them, or it's just more of a show, right? these fringe flags have meaning. We all know it, right? It has to do with admiralty jurisdiction. It has to do with what England did. We can go back to our own founding, 1628, the stamp tax. Now, what was going on then was the king had passed a law that he was taxing us, the colonists, with additional tax for stamps, for our letters. This was extremely unpopular amongst the colonists, extremely unpopular, and so they weren't paying it, and so the king started having the colonists arrested for not paying it. It was taxation without representation, because we were being taxed without having representation in Parliament to say no, we don't want to be taxed. And so we weren't permitted. This is what led to the Boston Tea Party. This is what led to the Revolutionary War and all these things. But it was so unpopular amongst colonists that the king couldn't find a jury that would find anybody guilty of that particular offense. You know, people would not pay the tax, and then they'd get arrested, and then the jury would say, no, not guilty. And it was pissing the king off. So the king said, well, we're going to remove the jury trial, and we can do that by switching from a common law jurisdiction into admiralty jurisdiction. Because admiralty is, of course, bankrupt, or not bankruptcy, but it's contract law. And so the king switched us into admiralty jurisdiction. Now, Thomas Jefferson, he actually wrote about this 3 separate times within the Declaration of Independence. Made 3 separate references to it. One of which he said that we are subject to a jurisdiction foreign to our laws. He was referring to, this admiralty jurisdiction, this switching over. The next thing he said is that he said in most cases we've been deprived of the right to trial by jury. That was also a reference to the stamp tax in 1628. And the reason why is because in admiralty jurisdiction, it's a contract. You're entering into contract with the judge or the judicial officer, and thus you're enslaving yourself through that contract. But you don't have the right to trial by jury within admiralty jurisdiction. You only have it under common law. And so it's a court martial. That's why they describe it as a court martial. Is that, just like in Guantanamo Bay, where those prisoners were coming in, being threatened, intimidated, forced into admitting they were guilty, and then they would be brought into one single judge advocate general that would act as both the accuser or both the judge and the jury in this sham process. That's what they were doing down in Guantanamo Bay with all of the enemy combatants there. That's what they're doing up here today, because down there it was also court martial. Up here, these judicial officers are portraying themselves as in the same way. So, you don't have a trial by jury within admiralty jurisdiction, which is why most state constitutions, Virginia state constitution, Massachusetts state constitution, that's why they say that the trial by jury shall not be infringed. Because when you go into admiralty jurisdiction, you place a fringe around the flag, the yellow fringe, right? Different colors, but ours is yellow. You place the yellow fringe around the flag, and that means we're in a different jurisdiction, admiralty jurisdiction in particular. And because there is no right to trial by jury when the flag has that fringe around it, then that is where that word comes from, that the right to trial by jury shall not be infringed, because the moment we place a fringe around a flag, our founders knew that the right to trial by jury goes away, it's gone. And so that's the history behind it. But we still see today, that people are still being arrested. They're still being pre-conviction detainment. They're still being held without indictments by a grand jury. They're still being pushed through plea bargains. So the fact that some fringe flags were removed, I don't see that as anything more than just a gloss over, because all of these courts are still operating in admiralty jurisdiction, and we won't see it change until we have a discharge of the debt, a release of the prisoners, the slaves. Court says he failed to invoke the right of waiver. We already went through that. Okay, so an attorney in Texas said that they don't have to do the grand jury. It's only a requirement for federal cases. Guys, that's what ChatGPT says, okay? If you want to go out to ChatGPT and ask them that question, then they're going to say, yeah, you only get a grand jury in the federal court. Because that's what they do. Just because that's what they do doesn't make it right. You got to question it. States do not have the right to enact their own alternative legislation, substitute them for the provisions guarantees of the Constitution, and then enforce those in violation of the Constitution of the United States, right? Because deprivation of rights under color of law says Any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. States cannot enact their own alternative legislation and then enforce those against the people of the United States. Constitutional Law 171 says, state courts and federal courts are equally obligated to guard and enforce every right secured by the Constitution. Okay? State courts are obligated to enforce them. State judges are bound to enforce them. Article 6. So no, Texas, I don't care what Texas says, because if Texas has a law that's in conflict with the Constitution of the United States, then we already know, just as Justice Marshall said, it is a proposition too plain to be contested that the Constitution controls any acts, statutes, customs, or rulings that are repugnant to it, or that the judiciary may alter the Constitution by a simple ruling made by a group of judges intent to advance the industry and not upon the will of the nation. To what purpose is the Constitution if the states are able to abridge the Constitution? Right? I mean, what good is the supreme law of the land if the state laws are supreme to that? So it doesn't matter what Texas says. It doesn't matter what Virginia says. What matters is what the Constitution says. And it says that no person shall be held to answer for capital or otherwise infamous crime unless a presentment or indictment of a grand jury. So when Texas says we don't have to have it, well, whoever's made that statement, whoever enforced that law is committing a crime called deprivation of rights in the code of law. And when two or more people do it, it's conspiracy to deprive rights. And when they have a kidnapping that occurs in conjunction with it, now you have a crime that's punishable by death. So I don't care what Texas says. They're acting unconstitutionally. So that's why we got to do this. Not because we want these people to get over on whatever it was that they did. We want government to accept the fact that government, you got laws as well, and you have to follow those laws. And if you don't follow those laws, then you guys are criminals. And if our leaders are criminals, then I'm not going to hold the people accountable for the crimes they commit, because we're just doing what you show us to do. If you don't want the people to be criminals, then you guys got to stop being criminals. And if you aren't willing to do that, then great. Well, then we're all criminals, and nobody can be guilty. So, that's why crime has to be fought from the top down. Because if criminality is simply a matter of learning from each other, then who we associate with, who leads us, who we follow. If they're criminals, then they're going to lead us toward criminality, and we don't want to go that way. So this isn't about getting people off on whatever crimes they committed. It's about holding government accountable for the direction that they're leading us, and making them obey the will of the people. Because they're responsible for these people in prison. They're responsible for the mass incarceration. They're responsible for the degradation of society and the erosion of the familial unit because of their practices of stealing children and all the rest. So, I don't want people to continue to look in the wrong direction and say, "Oh, all these bad people are going to get out." These are just bad people. They're not bad. They were led to be bad by our own government. It's our government that's doing this. So, anyway, all right, I gotta go and head to bed, and because I gotta get out first thing in the morning. So I've got one night here, and tomorrow I should be in Dallas tomorrow. So, all right, have a good night, guys. Thank you so much. God bless. Have a great night.